Now we're going to turn our attention to Utah, where earlier this week, Kathryn Restelli pled guilty to killing her husband with the help of her mother and brother. Matthew Restelli was shot and killed on July 12, 2024, when he went to Utah to pick up his wife, Kathryn, or so he thought, at her mother's house. Upon arriving, Kathryn's brother, Kevin Ellis, shot Restelli in what he told police at the time was self-defense. However, details of the shooting seemed very suspicious to police. They later uncovered messages and searched histories that indicated that Kathryn's desire was to get rid of her husband. Then she decided to plead guilty. Let's go into court now and watch as Kathryn Restelli says, "I did it."
Ms. Restelli, this is Judge Griffin. Can you hear me?
Yes, Your Honor.
All right. Did you read the statement of defendant in support of guilty plea that was prepared for you by your attorney, or did he read it to you?
Both.
All right. Do you have any questions regarding the information, the warnings and rights that are contained in that document?
No, Your Honor.
Did you read carefully the factual basis of the admission of facts to support the elements that was contained in there as well? Did you carefully read through that?
Yes, Your Honor.
All right. Do you have any questions or concerns regarding those facts?
No, Your Honor.
I'll come back in a minute, but let me ask you this just to tee it up. Are any of the facts contained in the admission of facts incorrect, misstated, overstated, or otherwise wrong?
No, they seemed correct. They are correct.
They are correct, or they seem correct?
They are correct.
All right, thank you. I'll rely upon the rights that are contained in the statement in advance of plea. I'm going to go over your rights with you one more time because you are pleading guilty to several felonies. By pleading guilty today, you've already had your preliminary hearing, but by pleading guilty today, you are given up the right to a speedy jury trial of your peers. You're waiving the presumption of innocence, and you're waiving the right to require the state to prove your guilt beyond a reasonable doubt. You're also given up the right to call witnesses to come testify on your own behalf, and you're given up the right to cross-examine any witnesses who may be called to testify against you in any proceedings, including at trial. By pleading guilty today, you're also given up the right to present evidence through third parties as well, or through experts to present any type of evidence on your behalf. And with a guilty plea, you're given up the right against self-incrimination. What we mean by that is when you plead guilty, you've agreed to waive your right to remain silent and testify against yourself. Now, the statement in advance of plea states that you're pleading guilty to 2 second-degree felonies and a first-degree felony. Counts 1 and 3 that you're pleading guilty to, the agreement is they'll run consecutive. Second-degree felony is punishable by 1 to 15 years in prison. First-degree felony, in this case, is punishable by 5 years to life in prison. So rather than consecutive, that means you would serve each one separately, and then after the time it gets served on those, then you would serve the time on the third one. If I ran that consecutive, or if I ran it concurrent, you'd be serving the time on the third one all at the same time. I don't know how I'm going to sentence you on the third count or count 2 or the third charge. I'll make that decision at the time of sentencing after I've heard from you, your attorney, I've read the pre-sentence report, I've heard from the state and the victim's family, and then I'll make a final decision. I'm just required to let you know that for each second-degree felony, it's punishable by 1 to 15 years, and then for the first degree, it's 5 years to life. I did have a question I neglected to ask counsel in chambers. There is a firearm. Is there a firearm enhancement with a mandatory, isn't it like 3 years or something like that? Is that in play, counsel?
I don't believe so. Yeah, that would be my understanding as well.
Okay. I just want to make sure we didn't miss something there.
Okay.
All right. All right, then you also have the right to be sentenced to not less than 2, not more than 45 days from the date that you plead guilty. The important thing to keep in mind is prior to the time you're sentenced, if you believe it's appropriate, you could ask for permission to file a motion to withdraw your guilty pleas. That motion may or may not be granted. It's fact specific, but it's a right you have until you've been sentenced. Are you under the influence of drugs, alcohol, or medications right now, Ms. Restelli?
No, Your Honor.
You feel like you're thinking clearly?
Yes, Your Honor.
Has anybody tried to force or coerce you into entering into this plea deal and to waive your rights?
No, Your Honor.
Mr. Brown, for the record, did you explain to your client her constitutional rights? And do you believe she understands them?
Yes, she does.
And do you also explain to her enhanceability, Second Amendment, immigration consequences as applicable?
As applicable, yes.
And Ms. Restelli, do you wish to waive your rights to proceed forward?
Yes, Your Honor.
And before I do that, just for the record, you did give Mr. Brown permission to sign your name electronically to the statement in advance of plea?
Yes, Your Honor.
All right, I'll find you've only voluntarily intentionally waived your rights. I'll execute the statement in advance of plea now. We talked at the very beginning somewhat of the factual basis for this matter. Mr. Brown, for the record, you went over the mission of facts to support elements contained on pages 2, 3, and 4 of your client. Is that correct?
That's correct.
And you read that to her verbatim?
Yes.
All right. And you told me those omissions of facts to support the elements are correct. Is that true, Ms. Restelli?
Yes.
All right. So was there a stipulation as to how we're going to handle the facts, counsel? I believe we talked about it. Let's have you put it on the record now. Let's have the state do that first.
Well, the state is stipulating that the facts contained in this agreement are great and sufficient to support the plea on the 3 counts. We agree that if Ms. Restelli is, as she has acknowledged, agreeing that these are the facts, that we don't need to read the entirety of the facts on the audio record because they will be in the written.
Mr. Brown.
Yes, we agree to incorporate them via the plea statement.
All right. I'll set the party stipulation that the statement of facts have been incorporated in it. Do you have any objection to that as well, Ms. Restelli?
No, Your Honor.
All right, then. But formally, then, the facts that contain the omission of facts in the statement of events clear. Are those true and correct?
Yes, Your Honor.
All right, I'll find the factual basis to proceed forward. Then is to count 1, murder, domestic violence, a second-degree felony, punishable by 1 to 15 years in prison. How do you plead?
Guilty.
As it pertains to count 2, conspiracy to commit murder, domestic violence in Utah, second-degree felony. How do you plead?
Guilty.
As it pertains to count 3, felony discharge of a firearm, domestic violence, a first-degree felony. How do you plead?
Guilty.
Thank you. I'll find you've knowingly, voluntarily, intentionally entered the pleas. I will receive the same, and I will dismiss the remaining counts.
Thank you, Your Honor.
And then you formally waive time, correct?
Yes, we'll leave the time, and I'm available on that date, so I'll work.
September 9th at 9:30 work for the state as well?
It does, Judge.
All right, September 9th at 9:30 live, courtroom 2A. So I anticipate there may be several letters that may be filed. Let's make sure they're filed at least a week in advance. And then once your side's letters have been filed, would you email Faye, CC the opposing side, and let they know that they're there, so I can read them and think about the information contained in them instead of struggling early that morning to catch up with a whole bunch of things. Typically speaking, obviously the defendant has the right to address the court. She may have 1 or 2 people she wants to address me formally. I think the rest should be done through written statements. The state may have a couple of people or may not that want to address the court. That would be appropriate as well. Public balance should be done through written statements as well.
So the court knows we currently plan on flying out the victim's mother and brother.
And they would be
the one speaking. Yes.
That would be fine. And we have the family members, just have them submit a statement in writing, please. Any objection to that, Mr. Brown?
No, it's fine. The only, I guess, contingency is if we have some people that can't travel, maybe they can appear and maybe WebEx via WebEx.
Yeah, we can set up the WebEx. Just let us know the day before, or a day or 2 before. We'll make sure WebEx. Well, we'll try and make sure WebEx is working, right? Anything else we need to put on the record for the defense?
Well, thank you.
Anything from the state?
Thank you, Judge.
All right. Thank you, gentlemen. Thank you, Ms. Restelli. I'll see you. Pardon? Oh, yeah. Nearly forgot. I do want a PSR. Ms. Restelli, you need to get from the deputies an AP&P pack. You need to fill that out completely. If you have any questions regarding any of the information they're requesting from you, don't let it go. Contact Mr. Brand will be happy to help you. If it's not filled out, or if you don't cooperate with AP&P and they ask for me to continue sentencing, we'll just have to continue. It'll be another 45 days before we're ready to proceed forward. So it's in your best interest to make sure. Mr. Brown, obviously, very experienced. Reach out to him and he'll be able to help you on any issues you may have.
Thank you, Your Honor.
All right, thank you.
Thank you.
All right, don't see it a lot of times. Defendants admitting what they did in pleading guilty. Kathryn Restelli, she'll be back in court September 9th for sentencing, and there'll be a lot on the line there. You heard the judge say that she's facing 3 separate felonies. 2 of them are second level with a max of 15 years, but as part of this agreement, they are to be served consecutively. So one and then the other, meaning that you're looking max at 30 years, probably comes in around 25, and then the big daddy is a 5 to life. That's where his honor will decide whether or not she sees the light of day. Ashley Bargainquest is watching along with us, and Tinez, as they call it, Martinez, California. Ashley, happy Friday to you. This decision by this defendant. We don't see it a lot. You know, a lot of times people want to roll the dice and go to trial. She clearly wants something to look forward to, and that is the opportunity to see the light of day outside of prison walls. But she's not expected to testify necessarily against her family in that she's being sentenced. You know, a lot of times we see them plead guilty and then you don't get sentenced till after the other trials. Not the case here. She's just really putting her fate in the hands of the judge. Your thoughts?
Yeah, thank you so much for having me. And it is interesting to see the pieces that are missing from a deal like this that you would usually see. Because as you've indicated, we don't have the she will testify in the trial. Sentencing isn't being put over until after that trial. We don't have these same kind of protections that you would expect in admitting such serious charges and facing potentially life in prison. So there has to be something else going on that we just don't quite know. I am sure that the very specific stipulation of facts in this case was exchanged many times between counsel, because if she is not promised to testify, then it is that agreed to facts that a prosecutor would likely be depending on.
Yeah, and you know, and there's got to be a deal where prosecutors are going to recommend, 25, 30 tops. Otherwise, you wouldn't enter into this deal. But the judge at the end of the day is going to have to sign off on it. It's a fascinating case. I'm a little disappointed that they didn't read all the facts into the record there, because they stipulated that throwing the police report in, because the facts are crazy. In this case, basically, she doesn't like the ex. They're still married. Lures him to Utah with this story of, I can't drive, my foot's broken, can you help me back? And yeah, I'll do it, because he wants to save the marriage. And waiting there is the brother and the mom, and they're all there, and they kill the guy and then say it's self-defense, and it wasn't. She's busted. What a case. And the other two still going to trial. Their case is still pending. She'll be back in court September 9th.